Today, we're going to introduce you to what we refer to as the beneficiary designation. The definition of a beneficiary, obviously, is the person or entity that actually receives the death benefit. So who's going to get my money when I pass, might pass away? And you'll see in a moment there's a number of different beneficiaries that actually could be named. But the definition is the recipient, basically, who actually gets the money. Obviously, the beneficiary does have rights. In other words, they have the right to actually put in the claim. They have the right to contest the claim that they want. They do have rights, okay? However, I draw your attention to the fact that they're not a party to the actual contract itself. In other words, while they may step in because they are the rightful claimant and everything, and they have rights under that, but they have no rights under the actual contract itself. So therefore, if you remember in a previous session, we said that all the rights, the contractual rights, all lie with the insured and not with the beneficiary. But they do have rights under the law in terms of putting in their claim, contesting that claim if need be, and so on and so forth. Okay, it's all that. There are essentially two big classifications, you might say, of beneficiaries. The first one we refer to as a preferred beneficiary. The word preferred is very important because what we're saying is it's a preferred beneficiary. They sort of lie in a special classification on their own, and therefore monies left to preferred beneficiaries are creditor proof. In other words, if you want to bypass the estate, you would name them as beneficiaries. So even if your estate owes money, they cannot go after the preferred beneficiary because of the rules of the game. Basically, is that the preferred beneficiary receives the money essentially intact. In other words, there's no lien on them, whatever. So the estate itself could owe money to the creditors and everything, and certainly the creditors can go after that money at the estate level. But because these are preferred beneficiaries, basically then they really can't go after that money at all. And so you have obviously the obvious one is the spouse, whether it be a legal spouse or a common law spouse, a child, a grandchild, and of course your parents. Okay. So, in essence, you might say the preferred beneficiary, you might say to some degree or other, there's a degree of dependency, basically, and as a result, the proceeds are, in fact, creditor proof. Now, I draw your attention to child and grandchild because, in many cases, if the children are minors, in other words, under age 18, they can't actually receive any funds. Okay, so what happens if you do name a minor as a beneficiary, and which you can do? Okay? In other words, can you name a minor as a beneficiary? Absolutely, you can do that. But can the minor receive money? The answer is no. So what happens really is that if you do leave money to a minor, be it a child, a grandchild, or and they're minors, younger than 18, money will be paid basically to the public trustees, and the public trustees then will manage that money on behalf of that child until they're age 18. And then at age 18, all proceeds then will be, of course, handed over to that child because now they are of legal age. So one of the things we caution you when you name your children that are younger than 18 as beneficiaries, just be aware of the fact that they will not get the money directly. Okay, they will get it sort of indirectly, but the money, in fact, will be paid to a trustee of some sort of public trustee who will manage that money on behalf of that child or that grandchild. And then, of course, when they reach age 18, basically all proceeds then, along with interest, whatever it is that the money is there at age 18, all that money then will be handed over to that 18-year-old. Now, you may not want that to happen, in which case then there is a solution to that, which we'll talk about in a moment. But just be aware that these two here could pose some issues. Okay. So as I said, you can leave the beneficiary to a person or persons. Okay, so like I said, spouse, a child, grandchild, whatever it is, you can certainly do that. Okay, you can also leave it to a group of persons. So, for example, all my grandchildren, for example, or all my children. So you can make a blanket statement just like that. So any of your issues basically will receive the proceeds in equal proportion or however as that you decide to do it. You can also leave it to a business. In other words, the business needs the money. So, for example, key person insurance. Usually what will happen is the company, XYZ Inc., will buy an insurance policy, let's say, on my life because I'm a key person, and XYZ Inc. is also the beneficiary of the money and everything. And that is, again, to protect the company in the event of my loss and everything else, this financial hardship or whatever it is. So, therefore, the business could, in fact, become the beneficiary of the proceeds, okay? Also a partner. You were you and I are partners. I insure you, you insure me. So therefore, I'm the beneficiary on your policy. You're the beneficiary on my policy. So certainly a partner is part of the issue as well. You can also name a trust, and this is where we get into a situation where the trust in regards to children, for example. A trust, remember, is designed to speak for you when you can't. And so essentially, when you set up a trust, it is a legal entity, basically, and the money then will get paid into the trust. And then the trustees, the people who actually run the trust for you, will in fact manage that money based on direction or discretion that you gave them and everything. And the beneficiaries will be named accordingly in that trust as well. So I go back to the child or grandchild situation that were, let's say, minors. So as I said to you earlier, leaving monies to a minor, they're not going to get the money. Now, what will happen is they're going to go to a public trustee, they'll manage that money, and then age 18 the money gets released, okay? However, you can set up a trust, and that trust then will be the beneficiary of that money. You've already also appointed a trustee to manage that money. It could be a friend of yours, it could be a corporation, it could be a bank, it could be just a bunch of different ways that you can name a trust. And that money then will be professionally managed accordingly and everything, take care of that child and everything else. And then you may say at age 18, release the monies, or you may say, at age 18, really all I want you to do is, if my child goes to university, pay the tuition fees and everything, but retain the money otherwise. In other words, when you leave the money into a trust, you can dictate how that money is actually going to be dispersed. It may be dispersed at age 18 in its entirety. You may only use that to pay tuition fees, let's say, until they're age 25 when they graduate, or you may simply delay the whole payment until they're age 25. It's really up to you. So the idea of the trust is that it speaks for you when you can't. In other words, you're not there anymore, so who's going to speak on your behalf? The trust will speak, will in fact speak on your behalf. So usually we recommend that if you have a child or a grandchild, and they are younger than 18, don't leave the money directly to them. Leave it in a trust, and that way the trustees have direction based on what you gave them, and you then can manage that money, like I say, beyond the grave, as they call it. The other thing, of course, is the beneficiary is the estate. Okay, the estate. So we all have an estate. Anything that we own that has our name is basically considered an estate. If you have your $500,000 policy and you name the estate as the beneficiary, then the money will be paid on behalf of, in your name, on behalf to the estate and everything. The problem, of course, with naming the estate is that it will be subject to taxation, probate fees, whatever. It would also be, could be attacked. You might say by creditors. So if you owe money to a bunch of people and everything else, they will sue the estate. The insurance policy gets paid to the estate, and obviously that's going to be attacked. And so that's why I go back to the preferred beneficiaries, for example, whereby by leaving money directly to your spouse, directly to your children, whatever it is, or through the trust or whatever, the creditors cannot go after that money. But if you leave that money to the estate, then creditors can go after that money. So you may find that your intentions might have been good in leaving all this money to the estate to be distributed accordingly and so on and so forth. But the reality is that because you owe money, because you owe taxation, what you thought you were going to leave your beneficiary ends up getting diminished quite considerably as well. And so that's we usually discourage the estate if at all possible. So you should talk to your advisor, obviously, to make sure that the right combination is sort of is done. Okay. So in essence, what happens here basically is that you can name any of these or combinations of both. In other words, you don't have to have all in one spouse or one in one parent. You can have some to the parent, some to the spouse. It's really up to you, because remember, this is designed basically to speak for you when you can't. So if you were to decide before you died how you want your money distributed, then you should put it in paper basis. Okay, this is what I want to have. The other thing I have to draw your attention to is that a divorce does not negate the beneficiary designation. So if you have a marital breakdown and you name your spouse as the beneficiary, and then you get divorced and everything, so let's say marital breakdown and everything else, unless you notify the insurance company in writing to change the beneficiary and everything, then upon your death, whoever you named in the first place will in fact receive the funds, okay? Because the divorce and remarriage and all that does not negate the beneficiary designation. So it's very important that if you ever hear of your client getting a divorce and they have an insurance policy with you, you should get in touch with them as soon as possible to make sure that they change the beneficiary. Otherwise, what will happen is the old spouse, so to speak, will get the money, the new spouse will get nothing, and the whole thing becomes a litigation mess, which really you don't want. You don't really want to get involved. Okay. So subsequent to this, we're going to be talking about a couple of more things in terms of beneficiaries. So we'll leave it there for now.